Managing a property in probate can be overwhelming, especially when tenants are involved. I know exactly how this feels because I help executors and administrators every day with properties that are in probate. Now, if you're in this situation, you might be wondering, what are my legal responsibilities? How do I handle rent payments? Can I sell the property? I'm Jeremy Kritt. I'm a licensed real estate broker in the state of Texas and owner of Kritt Real Estate. And in this video, I'll break down exactly how to manage tenants in a property that's going through probate while protecting the estate's value. Before we dive in, please note this video is for informational purposes only, and it does not constitute legal advice. Always consult a licensed attorney for guidance specific to your situation. I am not an attorney. Okay, let's get into the first point. Point 1, locate and review the lease agreement. Your first step is to locate and review the tenant's lease agreement. This document outlines the rights and obligations between the landlord and the tenant. If letters of testamentary or administration haven't been issued yet, it's crucial to understand the lease terms. I've seen situations where no written lease agreement existed, and it can be very costly because without a written agreement, there can be many disputes. If you can't find the lease, consult an attorney as soon as possible. Point 2, honoring existing lease agreements. As the estate's representative, you're legally required to honor any active lease agreements. This means tenants can remain in the property under the same terms until the lease expires. Review the lease with an attorney to fully understand what obligations the estate must fulfill if you don't understand what's in the lease agreement. Point 3, avoid informal deals with tenants. This is a really big one. It's natural to feel compassion for tenants, especially if they had a close relationship with the decedent. However, offering informal deals, such as reduced rent in exchange for property maintenance, can create legal complications. I've seen many executors and administrators make informal arrangements simply for convenience, especially when managing the property from afar. This can be a costly mistake because it introduces unofficial agreements, increasing the risk of disputes. Keep all arrangements professional and aligned with the existing lease. If no lease exists, the risk is even greater, and you should contact your attorney for advice. Point 4, handling rent payments during probate. Until the property officially transfers ownership, rent payments should go to the deceased landlord's estate. Ideally, these payments would be deposited into the estate's trust account, but that account can't be opened until the letters of testamentary or administration and an EIN are obtained. So consult your probate attorney to determine how to properly handle these rent payments in the interim. But once you have the letters of testamentary or administration and you have the EIN number, your first thing that you should do after that point is open a bank account, and any money that the estate receives should go into that account. You should not commingle funds between the estate and your personal accounts. So keep them separate, makes it easier for accounting, keeps you compliant, and it's just the right way to do it. Point 5, selling the property with tenants in place. Ideally, the best scenario is to sell the property vacant after the tenant has moved out. This approach typically attracts more buyers and can lead to a higher sales price. However, this should not be considered the only option. Every situation must be carefully evaluated to determine the best course of action. You can sell the property with the tenant still in place by making the lease assumable by the buyer in the purchase agreement. And this is an option that's in the Texas real estate contract. But the success of this strategy often depends on the tenant's cooperation in allowing showings of the property. A cooperative tenant can make the process smooth and successful, while an uncooperative tenant may make property showings difficult, which could negatively impact the final sales price. However, This option, the option of selling the property with the tenant in place, it typically narrows your buyer pool to mainly investors. And it could be that in the end, an investor is going to buy this property when it's on the open market. But if it's only available to one particular kind of buyer, like an investor, then almost certainly it's going to negatively impact the sales price of that property. Point 6, document all tenant communication. Documenting all communication with tenants is critical. Follow up verbal conversations with written summaries via email and confirm what was discussed. This protects the estate from misunderstandings and potential disputes. Ideally, keep all communication in written form, and if you're not sure, contact your attorney. Now I want to offer some final thoughts. I've covered only some important considerations when managing tenants in a probated property. Every situation is unique, and there may be additional factors to evaluate depending on the specific circumstances. Taking a thoughtful and informed approach is essential to protecting the estate's value. Handling tenants in a probated property can be challenging, but you don't have to do it alone. At Kritt Real Estate, I specialize in helping estate representatives like you manage these complexities while safeguarding the estate's value. If you're in the state of Texas and you find yourself as a executor or administrator of a probated estate, feel free to give me a call. My information will be in the description of this video. And as long as you're in Texas, I'm happy to talk to you about your specific situation and how I can help you sell this property for way more money than you could get any other way and have a smooth, enjoyable transaction. Thank you very much, and I look forward to hearing from you, and I hope you found value in this video.